Marine and maritime law in South Africa. The reach of the law extends beyond the land territory of South Africa into the ocean surrounding it. In that environment, the legal regime presents a level of complexity not altogether different from the interaction between the various bodies of water that make the southern tip of Africa such a prime area for marine and maritime research. One of the reasons for that complexity is that the sea is divided into a number of maritime zones that are governed by different legal regimes. A country's internal waters and the territorial sea are nearest to the coast and stretch up to 12 nautical miles from the baseline. Those waters are part of the South African territory, and therefore the whole corpus of South African law applies. The Exclusive Economic Zone, or EEZ, is beyond the territorial sea and extends to 200 nautical miles from the baseline. Although the EEZ isn't part of the South African territory, South Africa has within it exclusive right to explore, exploit, conserve and manage the living and non-living natural resources. South Africa also has exclusive right with regard to other activities for the economic exploration and exploitation of the EEZ, such as the production of energy from the water, current and winds. Along most of the EEZ's outer limit, those rights extend even further out on and within the continental shelf. It is only beyond the outer edge of the South African continental shelf that the international seabed area start, the non-living resources of which are the common heritage of humankind. The waters beyond the EEZ constitute the high seas, where all states enjoy a wide range of freedom. A second reason for the complexity of marine and maritime law in South Africa is that the largely borderless nature of the marine environment and most of the activities humans engage in at sea result in an unusually high degree of integration between two usually quite distinct legal systems. On the one hand, international law includes the contractual and customary rules governing the interaction between states at sea. On the other hand, the rules the South African organs of state apply to the natural and juristic person over whom they have authority are part of South African domestic law. The latter distinguishes between maritime law with a largely business and procedural focus and marine law with a public interest approach. A third factor compounding the complexity of marine and maritime law is the wide variety of conflicting interests at stake. On the one hand, the law takes into account the often opposing claim of coastal states, while on the other, it considers other states that also want to use the maritime zone under the jurisdiction of the coastal state. The law also attempts to find a balance between the demands made by various kinds of users in the same waters. For instance, how does one reconcile the need for marine scientific research with both security concern and exclusive right to the resources located in the area where the research is taking place? This chapter first stresses the importance of marine and maritime law in any strategy to fulfill the country's maritime ambitions by outlining the fast-changing policy and regulatory landscape at the global, continental, regional, and domestic levels. This also makes it possible to contextualize the synopsis of the state of current knowledge in the field in South Africa. Subsequently, the chapter identifies a number of knowledge gaps and concludes by suggesting a way forward. The policy and regulatory landscape. Global level. After the age of Western exploration, the seas were largely subject to a laissez-faire regime. This laissez-faire regime was adequate for the two main uses for the sea, navigation and fishing, that prevailed during this period, since ships were small and relatively few compared with today, and fish stocks were thought to be inexhaustible. The political, economic, and technological development associated with the Industrial Revolution slowly put pressure on both the natural resources and the regularization of navigation. A first attempt at codification of the body of rules, which had slowly developed during the previous centuries, failed in 1930 because, according to Churchill and Loeb 1999, it was not possible to reach agreement on the crucial question of the breadth of the territorial sea. After the Second World War, a second attempt was made during the First United Nations Conference on the Law of the Sea, or UNCLOS I, which was held in Geneva in 1958. The event resulted in the adoption of four conventions: the Convention on the Territorial Sea and the Contiguous Zone, UN 1958, the Convention on the High Seas, 1958, the Convention on the Continental Shelf, and the Convention on Fishing and Conservation of the Living Resources of the High Seas. According to Churchill and Lowe 1999, the first three of these international instruments were ratified by substantial numbers of states and were also based in large measure upon customary international law. For those reasons, the convention constitutes the core of the generally accepted rules of the law of the sea concerning maritime zone. The fourth convention, the Convention of Fishing and Conservation on the Living Resources of the High Seas, was less popular, perhaps partly because it went further than the existing obligation which customary law had imposed on states. In 1963, South Africa became a party to the four 1958 conventions. However, the newly independent state in the UN that had no say in the formulation of 1958 convention were in favor of reviewing the earlier law. Many states were increasingly concerned about the problem of overfishing and marine pollution off their coasts, neither of which could satisfactorily be controlled in the narrow jurisdictional limit on which the 1958 regime was based. These factors and the recognition that the various parts of the law of the sea were inextricably interrelated led to widespread support for a review of the whole of the law of the sea. After the failure of the Second Conference, UNCLOS II, once again because of the absence of agreement on the breadth of the territorial sea, the Third Conference, UNCLOS III, was convened in 1973. It concluded its work in 1982 with the adoption of the UN Convention on the Law of the Sea. The convention, which superseded the 1958 convention, represents a finely balanced package deal. It is referred to often, but inaccurately, as the Constitution of the Seas because it set the framework into which other related and more subject-specific international instruments are expected to fit. Some of these instruments were adopted long before 1982. For instance, a convention for the protection of submarine cables was adopted in 1884, and an international convention for the unification of certain rules relating to assistance and salvage at sea was adopted in 1910. The International Convention for the Unification of Certain Rules of Law Relating to Bills of Lading, also known as the Hague Rules, was adopted in 1924. However, as a reflection of the high level of interstate relations in the field, the great majority were adopted during the last half a century and include instruments as varied as the following. The 1966 International Convention on Load Line, the 1968 Protocol to amend the International Convention for the Unification of Certain Rules of Law relating to bills of lading, together with an amendment made in the Special Drawing Right (SDR) Protocol of 1979. Thank you.